Ready to take your verdicts and jury selection to the next level? Jury consultant Harry Plotkin and trial lawyer Dan Kramer are your ticket to tipping the scales before trial begins. You're not just picking a jury, you're picking justice. Produced and powered by LawPods.
Welcome back to another episode of Picking Justice. Harry, how you doing?
I'm doing great, my man. Always good to be taking a little tiny break from trials and talking and still talking about trials. So it never stops.
Yeah, you've been on quite the run lately, man, on some of these verdicts you're getting. It's impressive.
Thank you, man. As are you, man. You did a great job in a real tough case in a tough venue in San Diego recently. And we have Craig Peters, who has done an amazing job at least the last few years on some pretty tough cases, civil rights cases and product liability cases and things like that. So I'm excited to talk with you guys.
Yeah, we're excited to have the great Craig Peters here from Altair Law in San Francisco in the Bay Area, not far from where I grew up in Los Gatos. Craig's one of these guys that is just well-liked by everybody, has gotten crazy results, multiple 8-figure verdicts. And I love talking to him because he's taken on cases. I mean, I was at the CAOC convention with Craig, who was the former president, and he's telling me about this crazy case he's going to trial on and got this amazing result. It was like a false imprisonment case or something like that. Craig, sort of, yes?
False arrest, yeah.
False arrest, yeah. And then but he's also doing product cases, just traditional PI and all sorts of stuff. Because he's, I think, our first guest, Harry, who has a background as a criminal defense attorney for 13 years, was a public defender in Alameda or in San Francisco?
Contra Costa County and then San Francisco.
Okay.
Yeah.
Yeah. So he brings a lot of very interesting perspective on jury selection. So, Craig, let's hear about kind of your transition from public defender to civil in terms of jury selection. I know it's a very specific question, but go ahead.
Yeah. So growing up in the criminal law world, and this would be the late 90s, there was a very different approach to the approach that I think most people take now, certainly very different from the approach I take now, where as a public defender, the one thing you have going for you, if you've got anything going for you, is that the law is pretty good, right? This standard beyond a reasonable doubt should be a very high standard and a difficult standard for prosecutors to meet. And my interest was obviously in making sure that a jury would apply that. And so I spent time in voir dire trying to get jurors to assure me that they would follow the law. And it turns out that that's not a very successful way to get the jurors you're looking for, because at the end of the day, they can promise you all day. I don't think they're necessarily lying to you, but there's a subconscious element, as we all know, certainly as Harry knows, seeing the number of jurors that he sees, where people will frequently, they don't see themselves necessarily in the way that they actually are to the rest of the world. And that doesn't make them a liar. It's just a reality. I think we all have that. I'm sure there's ways in which people see me that I don't see myself. And so getting people to affirm positive beliefs is just not very effective in terms of making sure that you are getting people who will enforce or stay true to those quote unquote positive beliefs. So anyhow, that led to this switch. It's the switch that most of us have been using. I actually was fortunate pretty early in my career to have a very forward thinking boss who was very into training. His mantra was that we were the best legal representation that money couldn't buy, and that we were going to be the best lawyers on the planet, but nobody could pay for us. And that gave us a freedom, and kind of a mantle, if you will, that helped us kind of keep on keeping on in a otherwise really difficult environment, right, where everything's kind of stacked against you. So he sent us to Jerry Spence training, of all things. And this was before
Wow.
I think anybody had really even, I mean, people obviously knew who Jerry Spence was, but it wasn't really a thing yet. And they had a training in San Diego, I think it was at Palomar. And it really changed a lot of the way that I started thinking about my cases. I ended up meeting Josh Carton, who some of you might know, some of the listeners might know. He and I struck up a friendship, and I ultimately became the director of training actually for the public defender's office in San Francisco. And so I bring Josh in regularly, and then I do trainings myself with our folks to really build those skills on voir dire, because it's such a critically important part of the case. As I tell young lawyers, give me as much time. If you're a judge, all I want is I want you to give me as much time as I need on voir dire, and you can give me 4 hours to put on my case. I'm fine with that. If you're going to limit my hours in one place, limit me on the evidence, not on my voir dire. Because at the end of the day, if you don't have the right jurors, doesn't matter how much time you have, you're never going to get to the right result.
I like that. I've actually never thought about kind of if there was a finite amount of time a judge is going to give for the whole trial to give me more in the voir dire bucket. Does that work? When you have a judge saying like you have 40 minutes or 20 minutes and say, give me less on opening and closing?
So I've never had to actually do the trade-off itself, but I've made the argument, which I can't say has been effective with every judge, but many of them have seen that as sort of a promise by me that I'm going to be really efficient in putting on my case, which I then deliver on. So it's kind of giving them the message like, I know you want this thing to move along. I do too. The question is, where does it move along? And it moves along during the evidence phase, not during the voir dire phase. And part of my pitch too to the judge, and you just mentioned Dan, Carrier mentioned Dan had a case in San Diego. So my first civil trial after I left the public defender's office was in San Diego. I was doing plaintiff's work for people who were suffering from mesothelioma. And I worked for this firm that said, look, we basically only try cases in 3 jurisdictions. We try them in LA, San Francisco, and Alameda. That's it. They're all filed in one of those 3. We're going to give you about 6 months to kind of learn the science and get up to speed, and then we'll have you start trying cases. So this was month 2. They had a trial going in Alameda. They had another trial going in LA. They had, at the time, 3 trial lawyers, maybe in one of those 3. And this weird case that they had that was venued in San Diego because they couldn't get it anywhere else suddenly was going to go to trial. They couldn't get it settled. So, well, you're going to go try that case. So they sent me down to San Diego. And I was in front of Judge Taylor, who some of your listeners may know, who's somewhat infamous for a whole variety of reasons. One of which is that he has you voir dire the entire panel at one time.
He's actually our number 1 listener, Craig. So
Is he?
yeah.
I love.
No.
So
I mean, I like Tim Taylor. I really like him. Brian Panish is in trial in front of him right now.
Yeah.
So he's strict, but I think he's fair, but he's a smart
He
guy.
is. And actually I've stayed in contact with him since, I mean, that trial was, eons ago, but I love the idea of voir diring the entire panel at one time. And it's part of my pitch to judges now on why I should get more time for voir dire, because their interest is in making the jurors, the public that comes in, feel good about their experience as a potential juror, right? That's their interest. Well, how do you make people feel good?
Get them talking.
Don't make him sit on the sidelines for
Yeah.
a day or two.
You get them involved, right? Everybody wants to tell you what their opinion is, right? That's the nature of your podcast, right? That's like how you get people like me to come on because I get to talk about stuff, right? So if we have jurors come in, even if it's a quote unquote efficient, but they never get to say their piece, it doesn't feel, sure, it's great. It was more efficient. They got in and out of there faster, but it doesn't feel any more rewarding for them. And so this idea that you give everybody a shot to say their piece, I think actually builds greater confidence in the system. And that's my pitch to the judges is why, voir dire should take more time so we get to talk to more jurors.
Which will be all done. Once you're done, once you sit down, there's no more people to voir dire. Yeah.
Oh,
Well, this is I really want to explore this a little bit here because I think this is a very interesting perspective. You're one of the only attorneys who I think I've talked to who actually is pushing this to judges to do the whole panel. And I know Harry's got some thoughts on it, but my quick perspective is I've had to do it a few times recently. In San Diego, we had to do it, but we only had 45 minutes for 58 people, which made it pretty tough. The pros I like about it is, like you said, you get to know everybody. You know who's coming up. You know exactly who's coming up. You know the last person, how they feel, what they think, all that stuff, which I think has been a positive from it. Harry, what do you think are the positives from doing the whole panel?
I think the positives, yeah, you're not surprised or by who's coming up, and you can efficiently use your strikes. You know who, if I'm picking a jury where we've voir dired everybody, I know who the 6 worst people. I'm not afraid of like running through all our strikes quickly because I know, they're worse than the people coming up. It's fine. I mean,
Right.
And sometimes in cases you're like, we need to keep going and keep the defense going and get to the better jurors that are coming up a little bit later versus these first 12 or 15 jurors are like the best jurors we have. And we should probably try to hit the brakes as much as we can. So I think from a strategy perspective, I think it's better. And it's funny because we just Dan and I got an email from a listener from Arizona the other day who was asking us about how to handle a judge who was making the lawyers voir dire the jurors one-on-one in a room, right, Dan? And was saying, how the heck can I get them comfortable admitting biases if, usually in a group you can get a few people talking and they get the sense it's okay. And what do you do if it's one-on-one? And so, for those lawyers who complain about having to do the whole room, it could be worse. You could be doing them one-on-one and having to, voir dire.
I have a trial lawyer buddy, Dan Algalani in Connecticut, who the judge just leaves and the attorneys and just the prospective juror go in a room together and then they talk to him. He's like, it's like the Wild West. You can say whatever, the other side doesn't object. Like, you're just talking to this person, then they leave, the next person comes in, and then you kind of go back to the judge after that. You kind of work it out. It's very, very different, obviously. But Craig, I mean, I do want to hear, because I do think there's also a lot of downsides to having to do the whole panel, especially when you have 45 minutes for 58 people. But what's your philosophy? And maybe we're missing something. Maybe we should all be pushing for this.
Well, and the devil's always in the details, right? Yeah, 45 minutes is not enough time. The panel that I picked in front of Judge Taylor, we had 2 days, right? So I got basically a day, and then the defense got basically a day. Now I think there were 3 defendants or 4 defendants, something like that. But again, the argument is, look, give me 2 days with this jury, with this whole panel. Let me fully and fairly question them and find out how they feel and how they think, so we can figure out who the people are that aren't good for this particular jury, and then we're going to run through it. I mean, Lord knows if you've had a trial in front of Judge Taylor, no moss is growing on those floors there, right? Like, I mean, things are moving along. So I'm all for efficiency, but not just for efficiency's sake. It has to be placed in the right spot. And it is true, I think, from a lot of trials that I've watched other people do, and quite frankly, I'm sure from some of my own trials at times, where we have, kind of beaten a dead horse, that we're giving them a fact, we're giving them a fact again, and we're giving them a fact a third time, right? We can be more efficient. I learned that on that civil rights trial, and don't get me wrong, I wasn't happy about it, but the Judge Alsup, he gave me 8 hours to put on my case, 8 hours to put on a police misconduct case,
With
all
three different plaintiffs, right?
3 different plaintiffs, 7 officers in total. I mean, it was, it was crazy. Now, that was also federal court, so I also didn't get very much time to do voir dire, although there's ways you can, kind of work your way into squeezing a little more time out, with obstinate judges. I think we need to be better at educating judges and collaborating with the judiciary on how to do this thing called jury trials better. And it feels to me like the judicial system has become more open to that, as we've been more open to inviting them to our conferences and working with them and inviting defense attorneys and being more collaborative. And I think there's a real opportunity here, as the underpinnings of our democracy, this thing called the rule of law, is being seriously challenged. Now is the time when our government entities, particularly the judiciary, needs to step up and show that it can be that shining beacon on the hill. And we can't have it frustrates me to no end that we've got 58 counties in this state and they all act as separate little states, as opposed to having the 4th largest economy in the world using its scales of economy to provide an easier portal to find out what's going on in the courts, regardless of where you are, right? Why can't you log into one place and find out what's going on in Placer County versus San Diego versus Siskiyou?
Well, within every county, every judge has local rules, all this stuff. I totally agree with that. I mean, I think the biggest thing to get judges behind this is obviously, like you said, us showing that we can be efficient. And there's nothing worse. And I still make this mistake, but used to make it a lot more when I was younger, is just wasting time in jury selection by asking very difficult to understand questions,
Yeah.
spending, going to some seminars where they teach you to talk more than the jurors talk and spend, the first 15 minutes giving your intro. And it's like, dude, you haven't asked a question yet. Get to the point. And learned that very early on, real quick, when I got shut down after going to one of these seminars. But
if you're lucky, you're lucky, you'll get shut down by the judge. If you're not lucky, the judge will let you
that's a good point.
Make the jurors hate you and let you keep going. So,
and like, yeah, your time's up. You haven't asked a single question. But
well, the jurors just are sitting there hating your guts by the time you're done 15 minutes of their time.
Yeah, I don't get that whole movement there for a while. Yeah, I agree. I think it really is on us, and I think that's why, like you said, Craig, doing jury selection is the hardest part of trial. We always talk about this in these podcasts, and how are we going to be more efficient, And so obviously if you're doing a whole panel and say you have 2 hours, like how are you handling that? What's your efficient way? What's sort of your method to make sure you're getting to everybody?
Yeah, so in fairness, I've done it once with Judge Taylor. I've never convinced another judge to let me do it that way. But with Judge Taylor, we did, a lot of what we do now. I did a very quick kind of preamble about how we're looking for people who tend to, lean one way as opposed to another, and how that can be problematic in certain cases. I give them an example. And then I try to get as quickly as I can right to, okay, one of the issues in this case, we're asking for money. Who feels like my uncle, for instance. I use my uncle frequently in my voir dires. I think Harry's heard me do that shtick. But it's a way to kind of give an easy, off ramp, if you will, for the jurors to say, like, yeah, I feel like your uncle, right? Because they know I love my uncle. I tell them I love my uncle. I do love my uncle, but he wouldn't be a good juror on a PI case. He thinks, juries award too much money and people not taking responsibility for themselves. And so I want to get to that as quickly as possible. And I want to get a show of hands. And quite frankly, if you're willing to raise your hand on that question that I ask of 82 jurors or however many it is, and I've got somebody great like Harry Plotkin with me who's sitting there taking notes and knows who all those people are that raise their hand, I probably don't need to ask them another question. Now I would love to, and if I get a day and the defense gets a day, I'm probably going to do some follow up with some of them, particularly the ones that are earlier on, to get a little more understanding about why, and then use their why as who feels the same way, and then see how many more hands go up to see if I'm getting sort of a strong feeling, or if there's some people who maybe are on the fence that I could potentially live with. But that's how I'm gonna, I've got these 13 years, no jury consultants, nobody sitting second chair, just me trying to pick a jury, right? So I come into the civil world and I'm like, oh my God, like there's another attorney here. And then I have like a jury consultant who sees jurors all the time who can help me figure out what questions to ask. Like, that's amazing, right? And somebody, I think, as importantly, in that we sometimes, at least when I'm in these conferences and we're talking about voir dire, I think that gets overlooked a little bit, is somebody who's willing to push back. I'll never forget one of my early trials. And there was this one juror and she had an okay questionnaire. We asked some questions about loss. I asked some questions about loss of consortium. Her answers were real bad. And so we were, we're done. And now it's time to decide. And I say, well, I think this person's first and this person's second. And the jury consultant I had at the time, she's like, no, this lady's first. And I'm like, no. She had a good questionnaire and I know questions, but I can turn her around. And she looked at me and she said, no, you can't. You're not that good. Right. And that's kind of what we need sometimes, right? Because we start drinking our own Kool-Aid. And so we need somebody who will, you don't have to be confrontational, obviously. And anybody who's worked with Harry knows, like, he's great at this. He'll say, like, this is my feeling. You shouldn't have this person. And ultimately it's going to be the lawyer's choice to make the call, and they may feel differently. But to have that perspective, I think, when you're in the heat of battle, and from somebody who's seeing the jurors in a different way than you are, you're up on your feet walking around. They're not only watching the jurors as they're answering, but they're looking at the other jurors and their reactions. So they're gathering more information frequently than you're able to gather on your own. And I think that's what's so valuable. So I think if you've got somebody skilled with you, and you've got adequate time, having the whole panel question at one time has so many benefits. The ones that you and Harry both mentioned, Dan, that I'll take it every day of the week over this. You got to get back up. People get exhausted. We get exhausted. We get exhausted going back up to another six pack, particularly when you're on your seventh or eighth six pack, right? I mean, everybody feels exhausted. And
even the third. I
even
mean,
No,
even
I was gonna
the
say definitely the third.
even the
I mean,
second sometimes.
yeah, I mean, you're just like, okay, anyone have any feelings? Any feelings
Right?
about
Yeah.
what we talked about? It's just like, and you just kind of want to get it done, but you could be really missing some crucial information.
So that's another positive of the more jurors at once, the better, because how many, I mean, if you, for the listeners at home, how many times have you picked a jury and you're like, I got to ask these 10 questions. Each one of these 10 questions is super important. And then how many times do you ask the second or third panel all 10 questions? Never.
Yeah, never.
And so partly it's because you're tired, and partly it's because you don't want to bore the jurors. But you only have to ask it one time with those people, and also, I mean, I love the fact that the bigger the group, the less likely you are to have people just kind of, it's hard to find somebody who's going to break the ice and be the first one to say, I kind of feel like this kind of case is bullshit, or I kind of feel like you should only blame yourself if you get hurt on a motorcycle or whatever it is.
Yeah.
So the bigger the group, the easier it is for you to find that one person that you need to kind of get the others talking. And with a small group, like the one we were talking about, like the judges who only have you do it one at a time, you have to do that work over and over and over again, and it's tough to do. So jurors can.
Wait, so Harry,
help you.
Are you now a proponent of doing the whole room?
I mean, I didn't used to be, but in the last 3 minutes or so, Craig pulled me around. No, I mean, hey,
was this a long-held belief, Harry, that Craig Peters just
almost the entire webinar we've been doing right now, podcast. But no, I mean, the truth is, I mean, for me, I do these in other states too, and it's like every judge is different, and you just got to roll with it, and you got to find the benefits and think about, okay, what are the drawbacks of the way that we're doing it here that I have to make sure that, so one of those drawbacks in a whole room voir dire is it's really easy to leave somebody out and go, oh, we didn't talk to juror number 28 or 30. We didn't hear anything about him,
That's what happened to us when I picked that jury in San Diego with Claire. Like we had I think he was a former public defender, but he was on our panel and we're like, oh shit. Like he's the only one who we did not talk to. And we had to ding him because it was just we knew everyone else and we're like, okay. But it's just like we didn't talk, he was the only one I didn't talk to. But again, 45 minutes, 58 people is really
that's the
tough. Really
that's the hardest part. But I like but you look at the benefits, and these are some of the benefits. I don't mind doing the whole room as long as you get a decent amount of time.
Yeah. What's that? How much is that?
I mean, for me, so sometimes I'll write declarations. I did in that case for you, Dan, and I've done in other cases where we say, because this case has some complex issues or really sensitive issues or whatever it is, at least give us 3 to 5 minutes per person. I'm really okay with, I'm totally fine with 3. Less than 3 gets pretty dicey. When you're talking about a minute per person or a minute and 10 seconds per person, I mean, it's a little crazy. You can really only ask them one question each. And if you ask somebody 2 questions, now you're probably not asking somebody else a question. And I'm a big proponent in, don't ever assume that just because you ask a group question and someone doesn't raise their hands, that doesn't mean anything. I asked about, damages, and that guy didn't raise his hand, so he must be good. He might be the worst one. I've had a lot of times when I've told the lawyers, I remember there was one older woman, looked like a grandma, hadn't answered, raise her hand ever. And I go, ask her how she feels about emotional or non-economic damages. And I can't forget that she goes, well, I was raised to that when you get hurt, suck it up, buttercup. And she was like the worst one. And she didn't say a word for the entire jury selection until we specifically called on her. And I've seen that so many times that you got to talk to everybody, which is tougher, right, with the whole room, but you got to do it. Now, I would say one little kind of shortcut, do the math. You're going to seat 12 jurors and each side gets 6 strikes. And so that's, 24 jurors, and maybe there's going to be a little bit of cause and the alternates. Like, do the math. Like, if the judge is having you voir dire 60 people, in a lot of those cases, you don't need to talk anywhere past juror number 30 or 35 or 40. And if you're sitting there talking for 10 minutes to juror number 59, I'm probably sitting there shaking my head going, what are you doing? This guy's not even going to come in the panel at all. So as the room gets bigger, doesn't necessarily mean you have to talk to everybody. But so kind of think of it as like, okay, I got my 45 minutes to talk to the jurors I need to talk to.
Right. And that's also when you're doing that math, and I totally agree with Harry on the calculations there, but it's also knowing your judge. If you're going to have a judge that's really bad on cause, then that shrinks your panel. I mean, shrinks the people you have to talk to even more. If you have someone who's great on cause, then you may need to start talking to those.
Yeah. And if you feel like you're getting cause and you're going, I feel like I'm getting 5 or 6 or 7. Yeah. Now you got to add to the back end of the number of people you got to talk to.
But people always overlook that. It's just like there's a calculation here. Everyone is like in this conveyor belt. They're about to come on your panel. You got to like really think about the numbers there.
Yeah.
You do. Yeah.
And you can talk. When I did the 82 with Judge Taylor, turns out juror number 82 I had quite a bit to say, and I asked him on the first round some questions, and then as we got deeper in, I'd recognized the hands that were toward the back, and I said, look, I want you to know that I do care about your opinion. I've got a limited amount of time, and as you might have figured out, you're all sitting in order, so you're towards the back. You're least likely to get in, but you might get in, and so you need to keep paying attention. I want to keep seeing your hands when I ask the question, But for right now, I need to sort of focus on some of the folks up near the front. And then as we get along, I might come back to you. So please don't disengage. I still want you engaged. I still want you listening and raising your hand, but just know that I'm not calling you, not because I don't care about what you have to say, but just because I have a limited amount of time. And Judge Taylor was totally cool with it. He was like, yeah, because again, he's very much about efficiency. Although, in fairness, again, I mean, if you think about it, if it takes you 3 days to pick a jury, that's actually really efficient if you can then do your case in 5 days, right? So if every case is 8 days, essentially, 8 court days, that is not a huge tax overall on the court system. And I have yet to find the case that can't be done in 5 days. I mean, I regularly, I get asked to come in on a lot of cases. And at some point after I've come in, they'll be like, how long do you think it's going to take? Like 3 weeks? I'm like, 5 days. Like, what? How are we going to do it in 5 days? I said, we're going to do it in 5 days. So that's all the jury has time to pay attention to. By the time you get to week 3, they forgot what the hell happened in week 1. And to the extent that they remember it, it means that it was something really important and you probably didn't need all the rest of the stuff. So just cut that stuff out, shrink it down, give them what they need, and trust them. I mean, if you can pick a really good jury, you should trust that jury to not need every single bit of evidence, right? They just,
You're saying the whole, not just the plaintiff's case, the whole trial in 5 days,
yeah,
right?
we'll try
All the evidence in 5 days.
all of it.
And, so I know we talk jury selection mostly, but I do kinda wanna hear how you do that. You come into a case. I mean, in my firm, we put together a whole trial plan with every case we come into where, literally voir dire, motion limine voir dire, mini opening, all that stuff, lay out all the witnesses, plaintiff's case in chief, defense case in chief. I imagine you take a big picture. Do you just start cutting witnesses, the before and after witnesses? Are you cutting claims? Like, what's your kind of philosophy to get it to? Because I totally agree with you, by the way, and I'm trying to work on that too at my firm, is to shrink cases down. But how are you doing it? What's your method?
So it always starts with a verdict form, which means it's getting rid of claims, right? The more claims you have, the longer your verdict form is. The longer your verdict form is, the more opportunity there is to say no. More often than not, when you get a no, you're losing, right? So I want to just give them a few questions that are easy, that are easy to get to yes, and then get to damages. I just want to get to, as a public defender, one of my closest friends and mentors at the time said, Craig, in all of your cases, I can guarantee you one thing: the facts are bad. So just get past the facts and get to closing argument, right? Like just get past all that so you get to closing, because that's where you can maybe sway them, right? Now that's not how our cases work, but I feel like it's somewhat similar in that we just need to get past all of the stuff that precedes damages. We want to get to damages. That's where we want to live. And we spend a lot of time worried about and gnashing our teeth over, the liability and causation pieces, and oftentimes with good reason. But at the end of the day, piling more stuff on those areas is not necessarily going to do all that much good for you with the jury. And again, if you've got the right jury, then you don't have to worry so much about piling more stuff on to try and reinforce your causation argument, your liability argument. So and one of the things I learned when I was, doing plaintiff's asbestos work for people who were dying of mesothelioma was getting right to the heart. They were trying cases that were like 3, 4, 5 weeks long. I mean, it was crazy. 6 weeks. I mean, it was crazy how long they would take. And so I would put a expert on the stand and I'd say, Doctor, if we want to know something about how mesothelioma develops in somebody, could you help us with that? Yes, right. So right out of the gate, I want the jury to know that's what that person is there for. And said, tell us how that happens. And I would work with my experts to come up with something that was, 1, 2, or 3 sentences, depending on how complicated it was, that they could deliver to the jury. And then it didn't really matter what else came after that. I didn't mess around with their qualifications. I didn't mess around with how much they were getting charged, or they were charging us by the hour. I didn't care about any of that stuff, right? Because I don't think the juries do at the end of the day. They may use that stuff as an excuse to say why they found against you, but I've never had them, and that was because it wasn't because of those things. It was because of some other factual problem you had. It wasn't because of the doctor's qualifications. It wasn't because of how much they were charging. It wasn't because of any of those things. So that allows you to move through it very quickly. I mean, I think most of the time suck is in experts, and we over expert cases. And then on top of over experting them, once we get them, then we think we got to show how important they are and talk to them all day long.
It does. I totally agree with that. I mean, in this last trial, we had way too. It wasn't even a function. I mean, we kind of had to, but then the defense had even more,
Yeah.
and it just was a lot. It takes away from the emotion, and it's the two things we always talk about to get big verdicts. It's pissing off the jury, getting the jury super angry at the defendant, and then making them feel for what your client's gone through, right? And then, so I think you can get that piss off factor probably done in day one, right? If you do all the witnesses, you call the defense witnesses in California under CCP 776. Other states, I'm sure they have a similar way. You can get them pissed off out of the gate, and then, like, I agree, do the experts quick and get to the real damages. You can do your case in 3 days that way.
Right. And I like peppering the damage witnesses
Yeah, I
throughout.
do too.
I'm a big
Yeah,
fan of the 5-minute witness. The
me
person
too.
who, the guy on the corner store at the little bodega that, your client used to go in and see on the regular basis. And then your client was always the smiley, happy guy, right? Now he's got a brain injury or serious back injury or whatever it is. And the guy at the bodega never sees him anymore. And when he does, he looks like he's miserable, right? And maybe doesn't even know your client's name, right? I love calling that guy. Do you know my client here? Yeah. How do you know him? He used to come in all the time. What do you used to look like? He used to be a happy guy. How do you know? He's just smiling, laughing. He'd come in, say hello, we'd chit chat. Now what? I hardly ever see him. When I do, he just looks miserable. Do you know what's wrong with him? No, I have no idea. Thank you very much. Goodbye. Right?
Yeah, I love the 5-minute
Yeah.
witness.
And the
I
defense,
one time called like 8 in one day, maybe more, and it
yeah,
was just like the hairstylist, the boom, 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 boom. And nowadays, jurors, I mean, that's what they're used to. That's how they consume information anyway on
totally.
their phones. So
And
yeah.
then it bolsters it bolsters the wife or the boss or whoever it is that maybe, is a little closer to your client, and maybe the jurors could say, well, they have a dog in the fight. But now whatever they've said has just been endorsed by everybody else. So it makes their testimony all the more believable and credible.
And I think what moves the needle in terms of juror anger more in the experts is getting pissed at the defense experts more than your own experts. Your experts will, a lot of the things that they're saying the jurors already know, and I don't need an expert for that. But when you can use the defense experts to show these guys are lying, they're trying to take things out of context and cherry pick and deceive the jurors, or the defense, lawyers are not fitting them all the information.
Right.
I mean, and that doesn't take a long time to do it necessarily, but that's where the value, probably spending more time on the defense experts more than your own experts I think gives you most bang for your buck in terms of driving up the damages.
And same with your own client. That case, I think Dan, you and I talked about it at the convention, the guy who had hurt his neck and his lower back and ended up getting a couple of surgeries. And, I put him on, I think he was on the stand for in total 45 minutes. And I'd say maybe 15 of those minutes were mine. And the rest was the defense trying to cross-examine him, right? Like, his story had already been told by all those small sort of 5-minute, 8-minute witnesses. I had his work wife who was amazing. I found he sent me a guy who was
Are
actually
you using that term, work wife? That's like, isn't
she
that the new
called herself the work wife. Yeah,
Did she have a loss of consortium claim or
Yeah.
yeah. So I mean, those, so that he didn't have to tell his story by the time he got on the stand. They just needed to see him. Harry, you and I did a case where clients came in, we introduced them, and I don't know if you guys have talked about this on your podcast before or not, but the idea of not having your client at trial, but in very select moments. And I think, I've now come to the belief I always had my client there for the whole trial for a long time, and maybe 5, 6 years ago, right just before COVID, I stopped doing that, and I bring them in at the beginning and introduce them to the panel, and then I walk them out to the back of the
Yep.
courthouse because I want the jury to know who we're talking about. I want them to have a face, that goes with the name. But then they usually don't see him again until they testify.
I started doing that a few years ago too. So much better, I think.
It just keeps the focus where we want it, which is on the defendant, right?
And it can only go badly for the jury when they're sitting there looking at your client every day. There's really they're either getting desensitized to somebody who looks like they're hurt,
Mm-hmm.
or they're catching little clues. Hey, he's not that hurt. Did you see him? You see him get up so quickly? Do you see him, smiling, laughing in the hallway? There's really no benefit to having them there for the jurors to just scrutinize them the whole time. It's like a week-long Sabrosa almost.
That's right. And to bring this back to voir dire, which I think is the topic of this podcast, I will
Used to be.
actually ask the jurors about that during voir dire, and I'll say, look, my client's not going to be here for most of this trial. I just want to know how all you feel about that. And and I usually will get a number of people not that many, although not nearly as many as I used to think I would get, which is people saying, "Well, I got to be here. Why don't they have to be here?" Right? That's what I thought everybody'd say. I actually don't get that many of those. I do get some people who are kind of quizzical. They tend to be the more conservative jurors who are like, "Well, I don't really understand why they wouldn't be here. I mean, this is their case. Why would they be here?" And I say, "Well, that's a really good question. Does anybody else have any thoughts?" And I never give them, my answer. I wait for it and have gotten it every single time in voir dire, which is, well, it might be really hard for them to listen to what's going to happen here. It might be really hard for them to sit through a whole trial. It might be hard for them to relive this experience all over again. And once I get that, then I will give them, yeah. And I'm the one who's asking them not to be here. So if you're gonna blame anybody, you blame me. But I'm asking them not to be here because part of my job is to represent them. Part of that includes protecting them. And
So that's interesting because I used to really worry about that too. Like, how's that going to look? They're going to all hate me later on. So I got to address them voir dire. Now I don't even waste the time on it. I do like the way you kind of handle it, but I don't even waste time on it because frankly, all those people, almost 99% of them have no idea how it's supposed to work. They don't know, is the client supposed to be there? Is the client not supposed to be there? They don't know how it all works. And so I don't even highlight it really. I do frequently have, defense attorneys be like, well, they'll ask the husband, well, where's your wife been like this whole time? And sometimes I'll object, sometimes I won't even give a shit and just be like, okay, this is not a big deal. Why do I need to highlight it? But I'm curious, Harry, your thoughts on, you know, I guess one, assuming you have plenty of time, so you have the time to ask it, is it worth addressing? Do you maybe get someone for cause from it? Is it information you need for your data? What do you think?
No, I actually don't like, I found that if you don't bring it up, jurors don't think about it. And when you bring it up, hey, my client's not going to be here, that's the only time that they really think about it. I don't think anybody, especially nowadays, post-COVID, when the courtrooms are usually pretty packed and everything, and there's not even any room for sometimes for, even a paralegal to sit sometimes. They don't really think about it unless you bring it up. And so, they're like, I don't know how this process works. So I found that when you do bring it up, you just start more people thinking, oh yeah, that's a good point. For me, I think I don't need that question to identify bad jurors. I mean, they're gonna complain about something about your case other than the plaintiff about being there. I just worry about, are there going to be otherwise good jurors who just start getting these thoughts in their head that, which is really nothing. I mean, it's, they're not being there is not something that really people notice or bother.
Yeah,
with.
it's low on my list in terms of, I
Yeah.
mean, it's on my list, which means I think it's important, but it's pretty low. And if I've got a stricture on my time, that's one of the ones that's not getting asked. I mean, I do think people do think they know how things work in a courtroom because they see it on TV. I think there are some expectations about how things will go in court, including that the clients will be there. I don't know. I don't feel like it's ever hurt me to bring it up. I mean, that just hasn't been my experience, but I also think that it's not as important as so many other issues that we do need to get information about, that it shouldn't be, cut from the list if you've got a limitation on time.
Yeah, I think that's probably more my point. It's, in terms of time saving. All right, let's thank our first sponsor. I'm very excited for this gentleman who has decided to support this show. He's a very good friend of mine, John Tisa of Tisa Film and Tech. He has been my trial tech, I think, for the last 10 years. One of my first big trials, he was there working for another company. John Tisa really is just one of the best out there, a very humble guy. But if you need a trial tech, someone that is literally going to work any hours, anytime, he is available. He's quick. Makes your trials seamless, easy. He can do it all, really. We use him for literally everything technological in trial. He does our depo clips. We play a lot of depos and opening throughout our case. He'll do clips on the fly. He helps me with all my PowerPoints and opening statement. He is my right-hand man at trial. He'll sit there in the hot seat. Great with exhibits. Really, I just can't speak highly enough of John Tisa from Tisa Film and Tech. He's doing cases throughout California, but I know he's starting to expand out of state. He has an amazing team of people. When he's in trial and I need him, he always gets me someone who is top notch, so I really can put on the best case. I can't recommend John Tisa from Tisa Film and Tech enough.
If you're trying to do all that stuff on your own, man, you're missing something in terms of prepping for the actual jury. So you guys, if you're trying a case, you need somebody doing that tech and all that stuff for you after hours. I mean, after hours, you're prepping for the next plaintiffs, you're not putting together like depo clips and demonstratives and things like that, right, Dan?
No, man. I mean, not at all. That recent verdict we had in San Diego, I mean, he was working with us. We had a lot of depo clips from video witnesses, like lay witnesses, and he put together this beautiful like montage. It was almost like a documentary, just all these like things these people were saying about my client who suffered a traumatic brain injury. And he put together this thing that was like a documentary that I was able to play in closing because it was all in evidence, and it just looked so good and so clean, and the jury really liked it. So can't speak highly enough of John Tisa.
Awesome. How do you spell his last name for the viewers who want to get in touch with him, or how do you get in touch with him?
Tisa, Tisa, Film and Tech, and his information will be on all of our promotional materials and all that. So John Tisa, one of the top out there. Our next sponsor, who is always supportive of our podcast and the Plaintiffs Bar, is Melissa Baldwin from Baldwin Settlements. She really is the go-to structured settlement vendor out there. She's another person that I have known for over a decade. Extremely supportive of the Plaintiffs Bar, CALA, CAOC, AAJ. She will get the best deals for your clients, get them the most money in their pockets from a structured settlement. She works great with clients who may not be that sophisticated. I had a really catastrophic injury death or not a death, but it was nearly a death, where my client was not very sophisticated. He had some drug issues, and she was able to speak at his level and get him to do a structure that really helped set him up and his family up for the rest of their lives. Got him a great rate. She also structures attorney's fees, which is something I've started to do lately, just structuring fees so you can kind of have a little nest egg built up for either your business or yourself. Melissa Baldwin from Baldwin Settlements, really just a fantastic person, great businesswoman, a great mother, and a great friend who I highly recommend. Melissa Baldwin from Baldwin Settlements. So with that, thank you to our sponsors. Let's get back to this great show we got. You know, before the break, we were talking about, I'm always curious how different attorneys set up their voir dire, like their process, and like you come in a case, like you talk about your list. So what's kind of the Craig Peters approach to each different case, and like how you literally put pen to paper to prepare for your voir dire?
Yeah, so I'm looking at, what my bad facts are. I mean, I love the fact that we get mini openings now. All but one case I've elected to use a mini opening because I think it gives you such a great opportunity to highlight the bad facts in your case. And in some ways, right, like I have a good friend from college, who's a super, like one of the nicest guys you ever want to meet. And he used to say, people are stupid. And what he meant was like, just kind of expect that people are stupid, and then you'll be less disappointed. And so the point being, right, like where you set the bar in life has a lot to do with the results you're going to get from life. And I think that's also true when it comes to picking a jury and trying a case. If you set the bar in your mini opening at this level, right? And they think that's your case. But then your case comes in and it's actually way up here, right? It's way better than they ever imagined it would be. It actually turns out it may not be way better. It just feels way better because those quote unquote bad facts you were telling them either aren't nearly as bad as you made them out to be, or there's some other facts that negate them or actually turn them into good facts, right? So, I think and that has been for a long time up until I think again, just pre-COVID, where we kind of everybody had a little bit of an Achilles heel. We were so like pumped about our own case, and we wanted to talk about the good facts, and we were worried about the bad facts. And so we wouldn't really give those bad facts in a way that kind of embraced them, that like, yeah, those are bad facts. They're real bad, right? It was like, yeah, there's this bad fact, but right. So to do the mini opening, so that's always my starting point. What are all my bad facts? I want to get them all into the mini opening. And then I want to make sure that that mini opening is done in a way that feels real honest, where I'm not trying to hedge any bets here. I'm not trying to win. In fact, on the contrary, I'm trying to lose. I'm trying to find the jurors that will embrace this mini opening and all these bad facts and say, yeah, those are a real problem for you. Some of which will allow me to get them off for cause.
Let me just, if you don't mind, real
Yep.
quick, just jumping in. So, and I definitely agree 100%. It's the mini opening is more leaning bad facts. I do think for our listeners that there is, and we've talked about this before on the podcast, there is sort of a fine line, right? Because I've seen attorneys do this where they'll think what something like you is like saying, like put your bad facts out there, and then they'll just shit on their case, right? They'll just make their case look like absolute dog shit. Like, this ambulance chaser, why the fuck are we even here? This is a terrible case. And I think it's important, especially for newer lawyers or who don't try as many cases, that's not the method either. That's not the right way to do it either. You do not want to make, and Harry has taught me this a lot, is that you really don't want to make your case look so bad that you're going to all of a sudden get 40 cause challenges. It means you're doing something wrong, I think. Harry, what do you, I mean, I know we've talked about this.
One thing that I always teach is the goal of a good mini opening should be to convince all the bad jurors, I've heard enough, this case sucks. But all your good jurors are sitting there going, I don't know if this is a terrible case or a good case, but I'm kind of curious. And I want to hear more about those details that, Craig or Dan didn't tell me about. They just said something like, you're going to hear everything that this company knew and what their, rules were and what they actually did and all that vague stuff. So I'm a big believer in, I totally agree. Keep all the good facts out. Don't mention any of the good facts specifically. All the bad facts should go in, but I think they do need to be sort of balanced out with a vague promise of why you're saying that it doesn't matter. You can say, I mean, Craig, we did one where ended up settling, but, hey, you're going to hear that these guys were off-roading and they were drinking and they weren't wearing their seatbelts and, all that stuff. But you get to decide here all about what actually happened and what the deal was with this product and see whether that had anything to do with why they were injured or not. And, and see what the company's promises were. You kind of make, so you have to get all those bad facts out, but you also have to sort of say, we're going to show you why that doesn't matter without telling them what the details are. You're just going to have to wait for the evidence so that the good jurors are like, I want to hear what the rest of the story is. And the bad jurors are like, I'm going to tell you in voir dire. I don't have to hear that. I know the story. I don't have to hear it doesn't matter. This guy's, drinking and driving off road.
That's enough.
Blame yourself. I don't care what the company did. Yeah. So
it's a really good point, Dan. And I do subscribe to what Harry is saying. And I guess I was overstating it because I feel like people don't tend to go far enough. They're bad facts, but you're right. Yeah. So like with a Polaris or Yamaha case, it's like, look, the thing rolled over and they became paraplegic and we don't think that should have happened, but here's what you're going to hear. Right. So that's kind of like, that's all our good jurors need, but here's what you're going to hear. They were drinking, they weren't wearing their seatbelts. And for a lot of people, right.
They go pretty fast.
And that's
and
what
all
I'm
those,
going to spend, that's what I'm spending my time talking about.
Yeah.
God bless the defense. They more often than not, they won't talk about any of their bad facts.
That's great when they don't.
Oh, it's really,
but I hear what Craig's saying. Craig, I totally agree. What you're saying is don't hold back any of your bad facts. Do not, if you have a bad fact and you don't mention it in your mini, you're losing a golden opportunity at getting rid of more jurors for cause.
Right.
And at the jurors thinking, oh, he was hiding it. You tell them that the first minute your mini opening, it's all out there.
Yeah.
I mean, so
and there's a psychology to that. When I teach trial skills to new lawyers, I frequently say, what is a trial about? And the answer is always like, oh, who's got the best facts? Who's got the best theory? Who can tell the best story? It's like, nope, that's all wrong. It's all about credibility. The jurors don't know what the hell to do, and they're sitting there. They know there's two teams, right? There's team blue and team red, or team A, team B, whatever, right? And they're just trying to figure out who they can trust, who they should believe, right? And that happens slowly but surely over time. And in that mini opening is your first opportunity, in my mind, it's your first opportunity to build credibility, because you're like, I'm going to tell you bad facts. I'm not afraid of them, and I want you to know them because I trust you.
One thing I wanted to ask Craig about, totally kind of different topic, but you made me think about it when we're talking about, doing criminal defense and PD work in the past, is one area that I see lawyers kind of missing in their voir dire list is voir diring people on the law. I actually rarely see lawyers do that in terms of, hey, this is one of the laws that you're going to be asked to enforce, but we're all human beings. Who kind of feels like that's an unfair law? And there's a lot of ones that we come across in civil law, not just non-economic damages, although that's probably the biggest one that some people have issues with, but, vicarious liability sometimes comes up. Some jurors think, like, why should FedEx be responsible for their driver, running a red light or whatever, or
aggravation of pre-existing condition, I think is like,
that's a big one.
Why should the defendant be held responsible for this person having arthritis before,
Yeah, one that our good friend Gene Sullivan just tried a case where somebody hired an unlicensed contractor, and in California that makes you the general contractor and you're on the hook for essentially their mistakes. But those are the things. And I know, Craig, so I always believe voir dire on those, but you do it in a way that you make them feel comfortable saying, hey, you don't have to agree with all the laws. Who feels that that's an unfair law? And would that be tough for you to enforce it? And Craig, I'm wondering how you dealt with that with the law, burden of proof in the criminal world, and maybe how you apply it now. But I'm sure you handled it. How did you handle it when you talked with the jurors about that burden of proof in criminal cases?
Yeah. So again, there was a trend. There was a trend line, and it started off on beyond a reasonable doubt's really high standard. It's important you hold people to that standard. Is that something you think you can do? What does it mean to you? What do you think beyond a reasonable doubt means? Try and get them to start to think about and define for themselves. But the the problem, again, as my friend Oscar would say, all the facts are bad, and all the laws are bad. People like laws and they like enforcing laws. And it turns out even really, liberal progressive people like them. Now, there are moments that you can get them to engage in jury nullification, which of course is something that on the defense side, the criminal defense side, is very attractive, particularly when you have laws that are punishing in really unfair ways that are predominantly affecting, one marginalized or disenfranchised community. It turns out it's really hard to voir dire on that because most judges will shut you down. It's this great irony that on the one hand, they are entitled to decide that the law says that it's okay to do what was being done, even when the judge has told them something differently, right? That jury nullification, there's actually case law that says it's okay. And yet the instructions say it's not. So it is a very tricky area to try to voir dire on. And as a result, my experience, at least as a public defender, and I'm not sure what's happening now in the criminal defense world in this area, but I would try to find folks that had belief systems that I thought would likely than not at least make them open to the idea of some type of jury nullification if they felt that the facts of my case were particularly unfair to hold somebody responsible.
You're talking about laws that are not benefiting your client in these cases, right? Like
Yeah, I
ones
mean,
that, hey, it's,
right.
Jaywalking, you're going to, 3 strikes out, you're out on jaywalking or something like that. And,
Right. It turns out
and
there's
things
really
like
only
that. Yeah.
one law that benefits our client, and it's beyond a reasonable doubt, right?
Yeah. In the
If you're on
criminal
the defense
context.
side.
Yeah.
Almost all the other ones are, again, it's all bad, right?
Right.
Now you can find openings, and obviously that was a big part of what we were trying to do when we were defending our clients. Is you've got these very clear elements. All you have to do is find one element that isn't met, and you got a winner. So that was an area. If you had a case where it was an element missing or elements missing, where we would voir dire on, are you willing to follow each and every one? And are you willing to apply the same standard to each one, right? Each one requires you find beyond a reasonable doubt. The flip side of that and what we do now on the civil side, I think is a little trickier because again, we're just trying to create an easy glide path to a lot of yeses to really get to the damages part. And I don't know if, so for instance, on vicarious liability, I don't know if asking about the law specifically is going to get you. I mean, maybe that gets you somewhere. I mean, I'm thinking about like loss of consortium as a great, right? That's a great tool to find
That's a
out,
good one.
to
Yeah.
find bad jurors, right?
I mean, the law says you got to award it if there's a damage there. But a lot of people think that law
Or
seems like bullshit. It doesn't make sense to me. And that's kind of bullshit. And if they feel that way, if you don't get them off, they're going to get in their room and say, well, this is bullshit. Let's give a 0 or something. So,
that's right.
it's one of those many ones where the law, I always tell lawyers, don't ever assume that just because the law is says jurors have to do something, that means they're going to just do it.
Vicarious liability actually has kind of, because we do a lot of focus groups, and I do notice that they do sometimes talk, especially when you're dealing with like maybe a mom and pop shop or kind of like a smaller corporate defendant that like, the cashier made, hypothetically, just a cashier didn't sweep when they should have. I think in that situation, sometimes like I do bring it up. I say, look, like the law says this, but who feels that, if an employee who maybe doesn't even worked there for 1 month, screwed up, didn't follow the rules, who has trouble, say that the defendant corporation is 100% responsible. And it's something you probably want to find out, right?
Right. Yeah. And I agree. It's an area you want to question on. And to Harry's point, that even if they're like, well, okay, I guess I could follow that. I don't know that I agree with it. Right. That tells you a lot about them and the way that they think, because they haven't gotten to the next step as well. That person's probably in the best position to cover that loss because of the business they're in or what have you. Right. And I think you need at least a few jurors on your jury who are doing that second level thinking for us to win, because those are the ones who can sort of redirect those folks who aren't on our team.
And they always do, and it's always good the more I think you get them, even though, we may try to precondition, right? And so it's like they're going to say, well, corporations have the money for it. They're making money from it, so therefore that they should keep their property safe. And you start getting some really good stuff out there that I don't think you're exposing the good jurors for you for a cause opportunity from the defense, because then you could turn around from there. And then kind of what Harry especially talks about is the prehabbing your good jurors, to insulate them from a cause challenge potentially. There's a lot that the vicarious liability question, because Harry and I are about to start trial, and I think that's an important one, because we have a negligent worker who was there like a month and was power washing. And so it's something that I am concerned about. I focus group this case like 5 times, and every single time when they're deliberating, someone's brought it up, and a good juror always kind of brings them back to it. But it's definitely something that we often ignore, because the law says vicarious liability. And we all think he's wearing a Home Depot shirt, Home Depot's automatically responsible. But like in people's minds, it's not always just that black and white like we're talking about.
It's not always just that law. That's just an example.
Yeah,
but
yeah,
I think
yeah.
in every case, I think when you're picking a jury, you should identify at least one law that you're like, some people are just not, if they're not buying into this law, I'm going to lose them. Like in employment cases, there's always something. Employment, it's like, one of the laws says, if somebody gets sick with cancer and they're like, I need a year medical leave, you got to hold my job. And a lot of people are like, that's crazy. A year, that's insane. Or work restrictions or something, somebody can't lift 50 pounds anymore, just quit. So there's always a law in there that I think you want to find out, because you're going to get a lot of jurors that are going to say, yeah, I don't think that's right. And
Craig, I imagine in products cases, that's got to be an issue, right? I mean,
Yeah, I was about to say that. Yeah, products case, particularly when you've got John Cooper, who hurt his neck and his back, who was whatever 82 at the time, right? We could not. The courts prevented us from hooking in the mothership company out of Italy, so we were only suing the USA wholly owned subsidiary, which didn't design.
what was the product? Sorry, just for our listeners.
Yeah,
What's the
it was a piece of gym equipment, Techno Gym, right? They're one of the 10 largest gym equipment manufacturers in the world.
right, it didn't have a back, right? It didn't have like a thing that
Oh,
locked the seat.
it was on a track, and then at the back of and you had a little lever underneath the seat, like most seats do, that allows it to. Most seats go up and down from the lever. This one allows it to slide back and forth on this like upper body ergometer, so your arms are the right distance away. And so client goes to adjust the seat, clicks on the little thing, and it slides backwards, and it slides all the way off the track because
Because there's no end cap. Yeah.
no end cap, which is how they intended to design it.
Right.
Yeah, their thing was, well, yeah, we want it to come off because somebody who's in a wheelchair might need to get up onto that platform. You need to take the seat off. I'm like, oh, so if you do it that way, then you might end up with somebody in a wheelchair because they'll hurt themselves so badly that now they can go back and use the machine.
And now they can get back, keep using it. Yeah.
Jesus.
I mean, it was like, really? And you couldn't, I think, okay, I hear you, but there's another way to do this where you can both have it stop at the end and you can disconnect it if you needed it for a wheelchair, yeah, anyhow. But yeah, so we had the USA affiliate, and the lawyers were going to come in and say, look, we didn't design this thing, we didn't manufacture, we don't know anything about this thing. We just, get it from these people, these people in Italy, right? Who seem to have the same exact name and dictate everything that you do, right? Like you work for the same company, but there's this corporate, fallacy of, somehow they're different and distinct. So, talking about that in voir dire, like they're responsible as the ones who sold it. It doesn't matter if they designed it or not. In fact, it's not even going to be discussed in this case. Some people would be like, well, I want it to be discussed. That seems unfair. Does anybody feel that way? I want to know who actually designed it. Anybody, anybody feel like it would be really important for them to hold somebody responsible if they didn't know who designed it? And you get some hands raised. Now you get the discussion that we just talked about that you get on, vicarious liability or some of these others where someone will bring them around, but at least you get the people who, their gut instinct is, yeah, that seems problematic. Sometimes those folks aren't as bad as we might initially think, but oftentimes they are.
I do sort of like that just voir dire method of making a statement like that, like a statement that's like the defense would make, and just sit there, let it pause without the question, be like, who sort of agrees? with this, like just the state, whatever the statement is, then who sort of agrees with that. It's like, I like that, especially if you ask it in your tone of voice,
Yeah.
kind of like incredulous that someone would come in here and make that kind of claim. You
Yeah.
know, I like that.
But then if you ask, if you want to, you can say, who kind of feels a little differently and why? I mean,
Yeah.
you'll get people probably throwing your themes back at you, hey, well, I mean, if a company is going to sell a product, especially if that's like one of their main products, like you got to make sure that you got to like at least inspect it. You can't just like, get some product from some other country or whatever that, and just sell it to everybody and not look back. I mean, so
Right.
a lot of times and then now, the jurors who are okay with that law, not only are okay with it, but they have a good reason why, and they're buying into the themes that you're going to be presenting in trial. So,
And I don't know if you guys have talked about this in your other podcasts, because I've not listened to them all. You've had some amazing people on, by the way. Great lineup. You took a step down with me, and I appreciate you letting me do it. But one of the things that I didn't fully appreciate early on in my career when I was a public defender, until really it got driven home in one case, was how much good information jurors can give you that has nothing to do with whether you want them to be a juror or not. So we are in a day and age where I think most people do what you've been talking about, Dan and Harry, what you're constantly involved in, which is, focus group in our cases and doing it with big data and in person and all the different ways we can do it. And that's amazing. And I'm a huge proponent of that and think we should, because those people will give us good information back about how to theme our cases in a way that's going to resonate with everyday people. But sometimes they don't come up with the best ones, and it's the people actually in voir dire that do. I had a client who was charged with some gang charges and a robbery, and my biggest concern about I thought I could defense the case because I thought I could show that they didn't have enough evidence for one of the elements. But my client had like a lazy eye. He had one eye that did not track with his other eye. He had a scar right by his eye, and his hair was he had this funny kind of cowlick in his hair, and he just kind of looked a little mean, a little dangerous. There was something about him that just looked intimidating. And I thought, they're just going to look at him and they're going to think he's a bad dude. So I voir dired on it, and I get this lady who looks like she could be a librarian who said, I hear what you're saying. And actually, I will admit that that was my initial reaction when I saw your client. And then I reminded myself, you can't judge a book by its cover. And then there was a huge dude with tats all over him, this big pompadour hairdo. And he's like, yeah, can't judge a book by its cover. And then pretty soon, like the whole jury was there. And that was my theme. And the reason why I bring that up is because, I think we're used to hearing good things in voir dire that we can use as themes. We're used to hearing them in our focus groups as well. I think they're more powerful when they happen in voir dire, and you can use them because the jury has given you permission. In looking back on that case, I think if I had said you can't judge a book by its cover without that coming from the juror's mouth first, it probably wouldn't have resonated in the same way. But once it came out of their mouths, now it's their theme, it's not mine. And so
Well, especially when you say it and you look right at that juror, that powerful connection that you're giving it back. And then, yeah, totally.
So so if you've got a focus group and they've given you a good theme that you hadn't thought of, and you're like, oh, that's something that'll resonate. My suggestion would be if you can try to find a way to get that to come out in voir dire so that you're not the one as the proponent of it, but some juror becomes the proponent of it, even if it's a juror who doesn't stick around, so long as they heard it during voir dire. I think that adds a real heft to the.
What was your question for that case? What was the question about the way your clients looks? Because we deal with that in civil too. I mean, what's your setup to that?
Oh, is what I just told you. I said, I'm worried that as you look at him, you're going to think that he looks mean or dangerous. You're going to
Okay.
see that, he has one eye that doesn't track with another. He's got a scar next to his eye. He's got this hair that kind of looks a little unusual, right? I mean, it was really uncomfortable. I got to say, it was outside of a sex case that I had done like a couple months earlier. It was probably the most uncomfortable I'd ever been in voir dire and talking about a subject. But I just felt like I wasn't doing justice. And I told my client, I hope you don't feel offended by this, but I think it's really important in this case for success. I think our best chance of success is if we talk about this. And he was totally fine with it.
How do you say in a civil case, like, I don't know, slip and fall, whatever it is, but the client is all tatted up, maybe not as mean looking, but it's a worry that you have, that, juror is going to see this maybe single, 40s male who's all tatted up. slip and fell and injured and all that. Like, do you do it the same way? Like, what's
Same way.
your what?
Yeah, I do. I do it the same way. And, again, kind of going back to where we started at this podcast, right? It's people saying, like, oh, no, I'm not going to take that into account. Like, I don't think you can take that to the bank. And I think that's generally what you're going to get. Having said that, there is a value to, pointing something out, to naming something, to
Yeah,
identifying it and bringing it to the fore that now heightens everybody's attention to it. So it's easier when you get to the closing argument to remind everybody, look, if somebody starts wanting to talk about my client's looks, you remind them that we talked about this in voir dire and everybody agreed they weren't going to consider that, right? And that he's entitled to the same justice that everybody else is entitled to.
I've had the same thing happen recently with a few trials, I think mostly wrongful death trials, where the decedent was, had a lot of problems, crimes or addictions or, mental health issues and everything like that. And when we brought up, what are your thoughts on whether, somebody who's had those kind of struggles is worth any less to their spouse or to their, parents or to their children or whatever it is. And you get the same reaction. A lot of people going, no, no, no. I mean, just because somebody's got trouble doesn't mean that a daughter loves her dad any less, or a spouse loves, and a lot of them start picking up on it. So I think it's really powerful when you almost ask a question where you're asking the jurors to be the devil's advocate to something that they
That's right.
are going to push back on. That's super powerful.
and honestly, I think just in general, I think people relate more to someone that is vulnerable, has warts, than the perfect person. I think that it's hard. It's almost sometimes hard. Like, you have this like client who is just like had this perfect, great life. It's sometimes harder for jurors to relate to that person.
Yeah.
And
I think particularly in TBI cases, it's worth pointing out, it's not just the physical that you see, but the things that you can't see, because we are such a visual society now with, social media, et cetera. And talking about, like, look, my client's going to come in here and he's going to be able to string sentences together and listen to questions and give answers. And defense is going to say that he seems perfectly normal. There's no problem there, right? Anybody here feel like, yeah, if he can do all that, then he's normal. There's no problem inside in his brain. Anybody got feel that way? It's okay if you do, because that's normal. Because that's, if you met him at a grocery store, you'd think he was normal, right? But
yeah.
and so there's a little bit of preconditioning in there, but there's also a little bit of a, who's got that kind of bias? Who says, like, oh man, if I can't see it, that's going to be real hard.
Well, and you do frankly get a lot of jurors who go both sides, but you get a lot of good jurors who are going to say no. Like, some of the worst injuries you have, you can't see from the outside. And
They'll be like, my dad, had back pain his whole life, and he went to work and he was in construction every day, and you wouldn't be able to tell unless you saw him at home. And then you'd see him just go down on the couch and just be in pain the rest of the night. And then he'd go back to work. So yeah, you get these powerful stories, I think that.
Right.
and that also preempts any sub rosa too. That the defense may pull out one day.
Yep.
Eventually. Any final thoughts, Harry or Craig? This has been great. Went by fast.
Yeah, no, I mean, I wish we could keep talking about this, and we'll have to have Craig come on here again. But no, I mean, I think there's a lot of great stuff in here, and I'm super excited to apply some of these things to the next time I'm picking a jury.
Yeah, thank you to the great Craig Peters from Altair Law. He is doing just fantastic work for the entire plaintiffs bar. He was one of the great presidents of CAOC, which is the plaintiffs bar for the entire state of California. In and of itself, does so much for pushing the agenda that can really help our clients in the courtroom and with insurance companies, and passing legislation that really does make a difference and really helps not only save lives, makes the world a safer place, especially in today's time. And Craig is just one of those leaders in the whole state that really helps out and always willing to help newer and younger attorneys. So Craig, thank you so much for being on, man. We really appreciate it. Thank you to our sponsors for being on as well, making this possible. And lastly, thank you for Law Pods, who provide such great content for the legal community and really get this invaluable information out there. So Craig, thanks a lot, bro.
Thank you.
I appreciate it, man.
I appreciate it. It was a ton of fun. And voir dire
Good to
is
see you.
fun. So don't go to mediation. Just go to trial and do more voir dire.
Yeah, go to trial. Absolutely. Always go to trial. Put your demand out there. If they don't pay it, fuck them. Go to trial. That's my philosophy.
I second that emotion.
All right, guys. Thank you very much, everybody. We'll see you at the next one.
If you're enjoying the podcast, the best compliment you can give us is sharing it with a colleague who would find it valuable. For all the best clips from the podcast, follow us on social media. You can find those links in the show notes. Have a jury selection story to share? Email us at podcast@pickingjustice.com, and we may address it in a future episode. Until next time, remember, you're not just picking a jury, you're picking justice. Produced and powered by Law Pods.